It is now my great privilege to introduce another virtual keynote, and that is to Judge Theodor Meron. Again, from the earliest days of the summit, Judge Meron was one of our wisest advisors. He is the three-term president of what's called the International Residual Mechanism for Criminal Tribunals based at The Hague. And this is the judicial body that tries and has tried the genocide trials for the former Yugoslavia and for Rwanda. And Judge Meron is just a remarkable, remarkable human being. He is a leading scholar in the field. He is the person you may have seen who addressed the General Assembly of the United Nations on the anniversary of the liberation of Auschwitz. And he is in the United States. He is equally revered. He is he's a fellow of the American Academy of Arts and Sciences, who is the editor-in-chief of the American Journal of International Law. He is a revered figure. And he actually is unable to be with us in person today because he is receiving, as we speak, a Lifetime Achievement Award from his alma mater, Oxford University. And he's 97 years old. So he really, really deserves a Lifetime Achievement Award. But the other thing I want to say that I think he will allow me to say is one of the other reasons that he was so important to us in guiding us in creating the summit is because he himself is a child of the Holocaust, and many of his family members died. And because of who he was, we wanted to extend the invitation to him in person. So I flew over to London and I met with him. He invited me to the Oxford and Cambridge Club where I had never been. And the Archbishop of Canterbury was at the next table. It was all very thrilling. And he said to me, "You need to tell me before I say yes. Why me?" And I said, "Because you are a child of the Holocaust, and you took what happened to you and you converted it into being the most significant rule of law person in the world, in fighting hate and genocide in all its forms. And here in Pittsburgh, we have resolved to take what happened to us and to convert it into the most powerful force in the world in the fight against hate and extremism. So you're our kind of guy." And he just smiled and he said, "I'm in." And from that moment, he connected us to many of the people that you met here today. And so he has been an extraordinary global advisor to us. And in light, in particular, of the discussion that we heard this morning on the First Amendment, on the ability of a society to deserve and to support the First Amendment, his experience in different cultures around the world with free speech, with hate speech, and with what can come from hate speech, I think his comments today are particularly apt, and we're really privileged to be able to share them with you now.
I appreciate this invitation to address this important conference on eradicating hate. There is a clear link between hate, speech, and violence. Of course, we all want to criminalize speech which leads to violence, especially such as the murders in the Tree of Life of members of its three congregations. But do we also want to criminalize mere hate speech, or should this be left to individual societies? The Holocaust did not happen out of the blue. It was not Deus ex machina. Consider the incredibly effective anti-Semitic hate and annihilation campaign by Goebbels and his propaganda machine. Alas, that propaganda fell on fertile anti-Semitism, not only in Germany. As the UN Secretary General Guterres memorably said, the Holocaust was not simply the result of the insanity of the criminal Nazis. It was the culmination of centuries of hatred, scapegoating, and discrimination. That is why words matter, why United Nations Human Rights Conventions criminalize egregious hate speech. And the Genocide Convention, inspired by the Holocaust, treats direct and public incitement to genocide as a distinct, separate act of genocide, as a crime in itself, an inchoate crime, punishable even when acts of genocide do not result from the incitement. And of course, the crime of genocide requires specific intent or special intent to destroy a protected group in whole or in part. The Genocide Convention is the flagship of post-war international law aimed at preventing and punishing genocide, of which the Holocaust is a prime example. It also prohibits conspiracy to commit genocide. It outlaws certain acts, not only of killing simpliciter, but also of causing serious bodily or mental harm, or deliberately imposing on a group conditions of life calculated to bring about its physical destruction. The UN War Crimes Tribunals have fleshed out what such acts may entail. The UN War Crimes Tribunals have set new and significant legal precedents concerning what genocidal intent requires and what may constitute a genocidal act. I had the honor to preside over some of the seminal genocide cases. But it is important to recall that the ICTR and the ICTY statutes and the Genocide Convention before them punish as independent crimes not only the crime of genocide itself, but also related crimes, including complicity in genocide, direct and public incitement to commit genocide, and conspiracy to commit genocide. At the same time, the statutes of criminal tribunals provide for individuals to be held accountable under the principle of superior or command responsibility. In the case of General Tolimir, which involved the genocide in Srebrenica, the ICTY Appeals Chamber reasoned that under the ICTY statute, conspiracy to commit genocide is an inchoate crime, constituted as soon as there is an agreement among the conspirators to act for the purpose of committing genocide, while joint criminal enterprise is a form of committing, under the statute, a form of liability that requires the actual commission of the crime. And in the ICTR case of Nahimana Italia, the famous media case in which the ICTR considered the responsibility of persons involved in broadcasting and newspaper writings of hate speech and incitement to genocide, the ICTR Appeals Chamber distinguished here between the crime of genocide committed through instigation as a mode of liability on the one hand, and the crime of public and direct incitement to commit genocide on the other. According to the ICTR Appeals Chamber, where instigation is at issue, an accused will incur criminal responsibility only if the instigation in fact substantially contributed to the commission of the crime at stake. By contrast, direct and public incitement to commit genocide is in itself a crime, and it is not necessary to demonstrate that it substantially contributed to the commission of acts of genocide. The tribunal has thus drawn clear lessons from World War II. Propaganda for Holocaust can lead to atrocities such as the Holocaust and must be criminalized as soon as it happens without awaiting its catastrophic consequences. The Icpr media case was a landmark case, as it demonstrated that members of the media could be held accountable for broadcasts and publications that directly and publicly incite genocide. The judgment by the Icpr Appeals Chamber in that case also, and importantly, clarified many aspects of the law governing the crime of direct and public incitement to commit genocide, making it plain, for instance, that there is a difference between hate speech in general or speech inciting discrimination or violence and direct and public incitement to commit genocide. In that context, the Appeals Chamber underscored that direct incitement to commit genocide concerns a direct appeal to commit one of the acts prohibited in the Genocide Convention. And it must be more than a mere vague or indirect suggestion. At the same time, the Appeals Chamber recognized that a particular message may appear ambiguous on its face or to a given audience, or not contain an explicit appeal to commit genocide, and still, when viewed in its proper context, amount to direct incitement. The legal significance of the various rulings by international criminal courts cannot be overstated. Indeed, the tribunal's cases dealing with the law of genocide have been cited with approval in judgments of the International Court of Justice and other authorities, and this jurisprudence will undoubtedly shape the broader legal understanding of the crime of genocide for decades to come. I now turn to the second prong of my discussion, hate speech. Article 4 of the UN Racial Discrimination Convention obliges state parties to penalize the dissemination of ideas based on racial superiority or hatred and incitement to racial discrimination. When compared with United States law, this criminalization of speech and association on the basis of racist content violates the content-neutral protection afforded by the First Amendment doctrine of freedom of expression. But the different approach followed in the United States should not be explained on constitutional grounds alone. It also reflects, at least in the recent history, the traditional feeling of confidence and security in a developed and a relatively stable society, which, while failing to eradicate racism, has found orderly means of dealing with its racial problems, as well as the traditional preference for individual freedoms over the regulatory powers of the state. I must admit, however, that sometimes, and perhaps increasingly, I wonder whether our American society is still capable of protecting, or at least peacefully absorbing hate speech. Sadly, some hate speech which does not explicitly advocate violence does, in reality, result in violence and politically, ethnically, or religiously motivated killings. In some foreign countries, activities and organizations which in the United States would often be regarded as creating only a marginal possibility of violence and threat to public order might be regarded as a clear and present danger. If certain provisions of the Convention are overbroad when viewed against the United States legal and social system, it does not necessarily follow that they are overbroad for some other countries. It is difficult indeed to find a common legislative policy for the member states of the United Nations in view of their diverse stages of development and their different cultures, traditions, conditions of social peace and security, and so on. The purpose of my comments are, of course, is not, of course, to make a value judgment about which legal and social system is superior, but simply to state some of the relevant factors. Under customary international law, mere hate speech is not criminalized. And quite a few states have made reservations to Article 4 of the Racial Convention, including the United States, which stated that the American Constitution protects even vituperative and abusive language which does not qualify as a true threat to commit violence. In the drafting of the Genocide Convention, Soviet proposals that would have codified a ban on mere hate speech were not adopted, and the convention bans only speech that constitutes direct incitement to genocide. The debate over protecting hate speech has raged over decades. Some scholars argue that tolerant societies must themselves exemplify tolerance, and that the best antidote to malevolent speech is rational argument rather than suppression. Because hate speech and protected political discourse are often intertwined, we must exercise caution so as not to justify criminal sanctions for unpopular speech. This points to an ex-ante benefit of protecting political dissent, especially in nascent democracies. Others argue that no harm could come from the suppression of particularly odious ideas. And Justice Oliver Holmes demonstrated the complexity of this debate when he observed, and I quote, that every idea is an incitement. My own view is that the question of criminalizing hate speech is not a subject appropriate for one size fits all. It is a subject where the societal context must provide the approach appropriate for a particular state. But if we may differ on whether and how to criminalize hate speech, we should all unite in trying to combat hate. It is a tall order. Indeed, it is uncertain whether we will succeed. But must we try? Principles of humanity so require. This effort cannot be led by jurists alone. Parents, clergy, community leaders, teachers, media, and others must help and indeed lead. This conference commemorating the killings, the murders in Eitz Chaim is a good beginning, and I salute its organizers. Thank you.